This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes.
The 2011 105 SLST.
Is it there in the compilation?
Yeah. Page বলে দাও সব
11.5 SCC.
8708.
Page number 7.
Yes.
Now we'll kindly come to paragraph 32.
Page number? Page কত?
708.
Yes.
The paragraph 32, it needs a little emphasis that even one additional or different fact may make a world of difference between the conclusions in two cases, and blindly placing reliance on a decision is never proper. It is tried that while applying ratio, the court may not pick out a word or sentence from the judgment divorced from the context in which the said question arose for consideration. In this regard, the following words of Lord Denning quoted in so and so, but I am not reading the quotation. Now, this is the principle, my lord, which is accepted by Supreme Court. Therefore, the judgment of the division bench in a case where the issue was whether 2016 or 2025 would have no application as a matter of precedence. Now, this is one other, I am not in respect of the schedule to rules. What would be constitutional, my lord, implication? 2011 7 SCC. Page 789. Here in the schedule that additional 10 marks was incorporated.
Yes.
The paragraph 16 is the background of the facts. The procedure for direct recruitment is dealt with in part 4 of the rules, which requires inviting of applications, scrutiny of applications, recommendations of the commission, disqualification for appointment, and selection by the appointing authority. Part 5 of the rules deals with the procedure for recruitment by promotion, with which we are primarily concerned. I will not be troubling my lord with that for a long. Then kindly come to my lord paragraph 28. Rule 24(6) of the Rules 79 mandates that selection for promotion to all other higher posts or higher categories of posts in the service shall be made on the basis of merit and on the basis of seniority cum merit in the proportion of 50-50. In other words, 50% vacancies are to be filled up on the basis of merit, while remaining 50% in the promotion quota are to be filled up by seniority cum merit. The persons have to be within the appropriate position in the seniority list before they can be considered for promotion under the later category. Eligibility requirements have been specified under rules which candidates must satisfy to be considered under the seniority cum merit category. The other persons who are to be promoted to the post of DTO are on the basis of merit alone. Even if Schedule 2 of the rules does not exist, it is obligatory on the part of the respondent to evolve a methodology to make promotions purely on merit. Once the framers of the rules have intended to provide merit as the sole criteria of promotion, the appointing authority is not vested with the jurisdiction to waive the same or completely wipe out the same on a flimsy excuse such as one proposed in the present case. In the light of this, we now come to conduct the government, which we cannot but help to comment upon. Right from so and so, no examination has been conducted by the appropriate authority, despite the fact that they also issued notifications for holding exams on few of these occasions. If there was a representation from the Transport Inspectors Union, it cannot be considered as a sufficient cause or reason for not holding the examination for more than 10 years and causing serious prejudice to the candidates who might have been sufficiently meritorious to qualify in the exam and be considered for promotion to 50% of the post under the promotion quota. It is a matter of regret that the government can take such a stand before a court of law and expect the court to accept such a submission. It is expressly untenable. Once the rules stand clear. The authority concerned is expected to act in accordance with the law and not default the law. One who defeats the law by his unjustifiable or unjustifiable act is liable for the consequences of default. Now here, therefore, without the schedule, without really destroys the principal rule that it must be on the merit and the selection method. Therefore, the schedule Mulat cannot be contrary to the statutory rules. This is the principle. Now, beloved, I come to the point that the persons whose selections have been declared below null and void by the Supreme Court, they are untainted. They cannot get benefit Supreme Court judgment in another matter. This is 2003 Volume 2 Supreme Court cases, page 673.
Entry 30. Page number 467.
467.
67 to 467. 737.
Yes.
I will kindly come to paragraph 2, the facts, which is quite relevant for the purpose of similar consideration. In the past also, allotments of retail outlets for petroleum products were cancelled by this court.
Which paragraph are you referring?
Paragraph 2.
All right, 2.
May I read once again? In the past also, allotments of retail outlets for petroleum products were cancelled by this court after coming to the conclusion that the allotments made were arbitrary on account of political connections, motivations, and extraneous consideration. The tainted allotments were also cancelled by various orders of the High Court of Delhi. The allotments which are on merits and not tainted were not ordered to be cancelled. It's a matter of coincidence that exactly 7 years ago, on the front page of Indian Express, a news item appeared regarding the grant of retail outlets for petrol pumps on account of political and other connections. Now in August 2002, i.e. exactly 7 years later, again a news item appeared on the front page of the same newspaper about allotments to the near and dear ones of the political functions, attributing the same on account of political considerations. In common case, the court observed that for these allotments, a transparent and objective procedure has to be evolved based on reason, fair play, and non-arbitrariness. Now, this is the background. And now, kindly turn to, my lord, the relevant portions, paragraph 27 and 35. Paragraph 27.
Yes.
Article 14 guarantees to everyone equality before law. Unequals cannot be clubbed. The proposition is well settled and does not require reference to any precedent, though many decisions were cited. Likewise, an arbitrary exercise of executive power deserves to be quashed. Is a proposition which again does not require support of any precedent. It is equally well settled that an order passed without application of mind deserves to be annulled, being an arbitrary exercise of power. At the same time, we have no difficulty in accepting the proposition urged on behalf of the government that if two views are possible and government takes one of it, it would not be amenable to judicial review on the ground that the other view, according to the court, is a better view. Then we will kindly turn to paragraph 35-36. From that paragraph 34. In the case in hand, the paragraph 34. The only reason for the Amas cancellation was that a controversy had been raised. There was no application of mind to any case. Admittedly, none of the cases was examined. In Silekha Vidyarthi, this court held that arbitrariness is writ large on the impugned circular. In state action, public interest has to be prime guiding consideration. In Silekha Vidyarthi case, it was held that the impugned state action was taken with only one object in view, that is to terminate all existing appointments irrespective of the subsistence or expiry of the tenure or sustainability of the existing incumbents, and that by one omnibus order, the appointments of government council in the state were terminated. It was also noticed that no common reason applicable to all of them justifying their termination in one stroke or a reasonable ground had been shown. The position is similar in the present case. The expression public interest or probity in governance cannot be put in straitjacket. Public interest takes into its fold several factors. There cannot be any hard fast rule to determine what is public interest. The circumstances in each case would determine whether the government action was taken in public interest or was taken to uphold probity in governance. The role model for governance and decision taken thereof should manifestly equity, fair play, and justice. The cardinal principle of governance in a civilized society based on rule of law not only has to base on transparency but must create an impression that the decision making was motivated on the consideration of probity. The government has to rise above the nexus of vested interest, nepotism, and askew window dressing. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious action. Therefore, the principle of governance has to be tested on the touchstone of justice, equity, and fair play. And if the decision is not based on justice, equity, and fair play, and has taken into consideration other matters, though on the face of it, the decision may look legitimate, but as a matter of fact, the reasons are not based on values, but to achieve popular accolade, the decision cannot be allowed to operate. That after having the declaration from the highest court, which is again repeated by the court in last order, the order is final, that all these appointments are void. You are trying to give them appointment. Here, that's where paragraph 2 is placed. Some allotments were cancelled. You again wanted to bring them back to a different way. And that's this Supreme Court says this is against. I'm tempted to repeat this. The government has to rise above the nexus of vested interest and nepotism and askew window dressing. This was an attempt to window dress. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious actions. Therefore, the principle of governance has to be tested on touchstone of justice, equity, and fair play. If the decision is not based on justice, equity, and fair play, has to be taken into consideration other matters. Though on the face of it, the decision may look legitimate, but as a matter of fact, the reasons are not based on values, but to achieve popular accolade. Now, I am constrained to make reference, that after the Supreme Court judgment, the highest governing authority said, I don't bother about Supreme Court judgment. I have methods to see that these people are taken back to the job. We can't simply ignore this, or the public will. And court must take judicial notice of this fact. That's to accord the public accolade, if you say so. After having the judgment of Supreme Court, this is bad, and Supreme Court re-emphasizes on the last day, when all attempts are made to see that these appointments which are sought to be made are not interfered with by different applicants. And the next is, paragraph 45. Sorry, I missed it. The solution by reasoning to cancellation of all. The solution by resorting to cancellation of all was worse than the problem. Cure was worse than the disease. Equal treatment to unequals is nothing but inequality. To put both categories, tainted and the rest, on a par is wholly unjustified, arbitrary, unconstitutional, being violative of Article 14 of the Constitution. It is apparent from the guidelines that the dealership and distributorship were provided to be given to the allottees as a welfare measure. Even in respect of open category, there is a limitation for the income, so and so, but that is in the fact of the case. Therefore, once they were cancelled, paragraph 2 have started, they are tainted. They cannot be put at par with the persons like freshers. And you wanted to bring them, giving the additional 10 points. These are all not in consonance with the constitutional governance. সবগুলো দেখার দরকার নেই, আমি just I was just referred to the part of judicial review for the rules are concerned. 2024 volume 13 SCC 1. But I'm not piling up with Milord the judgment on the same point. I'm just giving Milord the relevant points. Page 1.
Entry number 9.6.
9C1. Page number 230. Only one.
Milord, paragraph 105. Straightway, Milord, I'm taking to Lordship without placing the other paragraphs where it deals with Milord the constitutional authority in detail. I'm not placing it. Therefore, I straightway come to the conclusion, paragraph 105. I got it.
Not yet. Which page do I get that?
Page 52 of the judgment.
Page 52 of the judgment.
Page 9.3.
Milchena? Milord, paragraph 105, Lordship got it?
Which page in the compilation will it be?
Start from page number 230.
I got that, but paragraph 105.
Paragraph 105. No, the Milchena.
346.
346.
Paragraph.
Oh.
কি দিয়েছো তুমি?
হ্যাঁ, না, না।
ওটা স্টেট অফ এইচপি তে অ্যাসোসিয়েট ডেমোক্রেটিক দিচ্ছ কেন? ভুল জাজমেন্ট দিয়েছো। Without ভুল
What
জাজমেন্ট।
is the cost title?
The state of Himachal Pradesh versus Yogendra Mohan
This
Shen.
is fun.
24-13 5 পেলে। No. 24-13 SCC page 1.
এটা কম্পারিশন খানটা ভালো আছে এই নেই 24-13
এই যশোরকে দাও বই দাও।
এই
আর 24
In the citation, it is
2014 2024
2024.
volume 13 Supreme Court cases
Yes.
page 1.
All right.
State of Himachal Pradesh versus Yogendra Mohan Sengupta.
All right.
The judgment of the just the retired Chief Justice. I'm just read out loudly.
Yes.
It could thus be clearly seen that this court, even when a provision in the constitution enabled parliament to make a law, thereby excluding the powers of judicial review, except under Article 136 of the Constitution, held that the power of judicial review vested in the High Courts under Article 226. And this court under Article 32 of the Constitution is an integral and essential feature of the Constitution, constituting part of its basic structure, and therefore the power of High Courts and this court to test the constitutional validity of legislation can never be ousted or excluded. This court further goes on to observe the power vested in the High Courts to exercise judicial superintendence over the decisions of all courts and tribunals within their respective jurisdiction is also a part of the basic structure. And always a point is sought to be taken that this judicial review is beyond the purview of going to the policy decision. Here this is good. No. This is the basic structure of the Constitution. Though the Constitution enabled Supreme Court only under 136, this court says no, this power is vested with the High Court under Article 226 also. Therefore, this court not has a power to interfere. And while Miller summing up on these points, another important judgment I feel is necessary. But once a statute was declared virus by the Supreme Court, but subsequently again, Milord, when the matter went up to the Supreme Court declared that ultra virus. So because it is permissible. This is a constitution, is a dynamic document, AI 1986 Supreme Court.
Page number 1.
I'm sure the many voices would come that the justice so mentioned in division decided so and so, therefore you can't do this. Though according to me, Justice Shane Millett had no occasion to deal with this. But this is AI 1986 Supreme Court 1444. This is corresponding to 1986 Volume 3 SEC, page 385. These principles have been reiterated later also, that I have not brought those judgments just to show that this is the basic judgment. Joshua AI আর দেয়া আছে। SEC দিয়েছো?
এখান থেকে করবেন প্যারাগ্রাফটা ট্যালি করুন।
না আমি বলছি বাইরে এখান থেকে। Not the paragraph 4 I shall rely upon. The paragraph begins with this counter affidavit. The counter affidavit does not explain why any distinction should be made between residential and non-residential buildings in the matter of affording the protection of provisions of the Act. To say that non-residential building is different from a residential building is merely to say what is self-evident and means nothing. Tenants of both kinds of buildings equally need the protection of the beneficent provisions of the Act. No attempt has been made to show that the tenants and non-residential buildings are in a disadvantageous position as compared with tenants of residential buildings, and therefore they need greater protection. There is and there can be no whisper to the effect. To illustrate by analogy, it is not enough to say that men and women are different and therefore they need not be paid equal wages even if they do equal work. The counter affidavit has repeatedly referred to the weaker sections of the people and stated that in order to protect the weaker sections of the people, a distinction has been made between so and so. It is difficult to understand how the exclusion of tenants who pay higher rent from the protection afforded by the Act will help to protect tenants belonging to the weaker sections of the community. It is one thing to say that tenants belonging to the weaker sections of the community need protection, and altogether different things to say that the denial of protection to tenants paying higher rents will protect the weaker sections of the society. Further, the distinction suggested in the counter appears to be quite antipathic to the actual provision because, as we pointed out earlier, there is no such ceiling in the case of tenants and non-residential buildings. Therefore, a tenant of non-residential building who is, I just skip over the facts, and then we must also observe here that whatever justification there have been in 73, when section 30 was amended by imposing a ceiling on rent payable by tenants to residential buildings to entitle them to seek a protection of the Act, the passage of time has made the ceiling utterly unreal. We are entitled to take judicial notice of the enormous multifold increase of rents throughout this country, particularly in urban areas. It is common knowledge today that the accommodation which one could possibly got in 1973 will today cost at least 5 times more. In these days, the universal day-to-day escalation of rentals, any ceiling such as so and so is totally artificial. As held by this court in such and such, a provision which was perfectly valid at the commencement of the Act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violative of Article 14. After referring to some of the earlier cases, Venkataramaya observed, the garb of constitutionality which it may have possessed earlier has become worn out, and its unconstitutionality is now brought out to a successful challenge. Therefore, if I may proceed, this is my duty. Sri So-and-so and Council for Tamil Nadu invited attention to some sentences from so-and-so, where referring to section 30, before it was amended in 73, it was observed, clause II exempts any residential building or part thereof occupied by any tenant if the monthly rent paid by him exceeds so-and-so. As the object of legislature clearly was that the protection of the beneficent provisions of the Act should be available only to small tenants, as they belong to the weaker section of the community and really need protection against exploitation by rapicous landlords. Those who can afford to pay higher rent would ordinarily be well-to-do people, and they would not be so much in it so and so. These observations were made in 74, soon after the amendment of Act in 73. They were made in a different context and not in the context of a challenge to the virus or the provisions as violative of Article 14. As we pointed out earlier, the argument based on protection of the weaker section of the community is entirely inconsistent with the protection given to tenants of non-residential buildings who are in a position to pay much higher rents. We are therefore satisfied that Section 32 will be struck down as violative, which was earlier declared valid, now declared not. Therefore, the Constitution is a dynamic document. It requires interpretation from time to time with the change of society and development. And again, in this case, conscience would prick. Judicial conscience, of course. The large scale of corruption, the entire selection having been set aside, an attempt was made to bring them back through back door. We, the freshers, cannot be equated with the persons who were found to be tainted and given the same door to entry, and that to giving an additional advantage. That's why this is unconscionable. These are my points, Milord. Anyway, this is not required even then. That if the government wants that the selection had proceeded, let it proceed without this 10 marks benefit. Let them be brought on the same level and let them be adjudged on merit. Let us see who is found to be meritorious. The ultimate purpose is to choose the meritorious person for the purpose of teaching, and that merit must be on the basis of the entry door eligibility. Nothing from back door.
After
But these are my submissions.
So would you restrict your submission or the challenge primarily to the 10 marks? If this 10 marks goes,
the rules makes eligibility clause as the entry point. That should be treated as a level playing field all throughout. These additional 10 marks, the percentage of merit could be, as I seen, on the basis of the marks of 10. 60% you get higher marks, 30%.
this I understand, but this will be one set of candidates regarding the 10 marks. There is another set where the eligibility marks 60% or 45 or something has.
That has been made. My challenge is all throughout. But confusion create karo. My challenge is all throughout. First, let the entire rule should be declared ultra virus. But
Yes.
these are not in consonance with the standard
Supreme Court
practice.
judgment
And the
also.
Supreme Court is not judgment also. But if an appeal is made, let there be some workable solution. It may also happen. Then the workable solution can only be made without awarding 10 marks, which is an additional boost. Though they are not entitled to participate.
Right. What will happen to those candidates who could not participate in the recruitment process because of the alteration of the
That's why
marks?
after this is declared, I said the first point, because I didn't think it should go. There should be clean slate. It should be completely de novo. That is my first plank of argument. These are alternative arguments, depending on the situation and the
I would like to hear the other petitioners also.
Because these 2016 candidates, are not entitled to participate. That's my first point. In view of the Supreme Court judgment. All. There is all. None is entitled to get without any benefit because their appointments are void.
No, at the same time, the court directs for conducting a separate recruitment process for them.
For the vacancies.
Yes.
Which was available then.
Right.
If you had undertaken the exercise of filling up 2016 vacancies, there was no difficulty because the candidates who had appeared all at the same point, they would have been contested. Now you have created this trouble. Now,
what was the declared vacancy in 2016?
Not in 2016, declared vacancy was
around 2,000 and 5,000.
Vacancy.
2009-10 12,915 or 5,700 something.
Yes, 12,500. I think that's available. State
Yeah.
can also.
All right. And in 2025, the vacancy has increased.
1,400.
Milord, in 2016, Milord, the vacancy, may please to Milord, note it down. 2016, it was 12,905. So for 910. In 2025, it is 23,212.
Classes 9 and 10.
9 and 10.
All right.
And then for recruitment to class 11, 12, 2016, it was 5,712. And in 25, it is 12,514. But I am not traveling now Group C and Group D. That will.
No, that is not.
And I am told, Milord, this is mentioned in the reputation. In
All right. All right.
paragraph 8.
All right. All right.
Paragraph 23. The paragraph.
না বলেনি কোথাও বলেনি তোমার কিছু ঠিক মতো পড়ো না সুপ্রিম কোর্ট জাজমেন্ট I'm just not at the risk of my reputation, reading out the Supreme Court judge. আমি প্রথম যেটা প্রেস করেছিলাম কোন প্যারাগ্রাফে কেন কিছু যখন আর্গু করি মাথা থাকে ডিভিশন বেঞ্চ চাইছি না আমি সুপ্রিম কোর্ট চাইছি প্যারাগ্রাফ 20. Paragraph 19, Milord, the following principles emerge from the aforesaid discussion. Supreme Court.
Paragraph 19 of the Supreme Court judgment.
Yes.
All right.
Page 76.
All right.
When an in-depth factual inquiry reveals systematic irregularities, such as malice or fraud that undermine the integrity of the entire selection process. Milord, I have been repeatedly trying to highlight this. The result should be cancelled in its entirety. However, if when possible, segregation of tainted and untainted candidates should be done in consonance with fairness equity, the decision to cancel the selection en masse must be based on the satisfaction derived from sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable, certainty of systematic malice, the probability test applicable. Despite the inconvenience caused to untainted candidates when broad and deep manipulation selection was proven, due weightage has to be given to maintaining the purity of the selection process. Individual notice hearing may not be necessary. This is the legal finding, and then, in our opinion, this is a case where the entire selection process has been vitiated and tainted beyond resolution. But what is the impact of this? Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selection are denuded. The High Court has referred the illegalities. I am not troubling my lot with that. In this background, now the directions come at conclusion. Paragraph 45. After having those legal findings, now the question comes to the Supreme Court for relief. And while relief, the Supreme Court has exercised power of Article 142 also in few cases. I should love that. The asked questions relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates were appointed must be terminated and they should be required to refund salaries, payments, and so. Their appointments were the result of fraud. This amounts to cheating Therefore, we see no justification to alter this direction. First, so for the tainted categories list have not yet been published. Supreme Court has directed this court to ensure the list is published. Nobody slips in. Then for candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to egregious violations of illegalities which violated Article 14 and 16. But if the selection is set aside on the ground of violation of the constitutional provision, the constitutional body cannot take a turn around and say we'll through them back door. Therefore, these people also does not have any right. That's why I had cited the judgment of petroleum dealers, which was once set at naught. The Supreme Court said you cannot bring them back and put it at the same plane that of the untainted people. Therefore, this is the position, my lord. I would therefore appeal your lordship, my lord, can you consider the entire aspect and ensure that the selection process for teachers are made, my lord, absolutely beyond reasonable doubt to instill confidence in the minds of the, my lord, the society, which is much more important than any other thing. Deeply honest.
The other petitioners,
I was appealing in item 27.
Now,
27,
Judgment.
which item?
Disable.
49 disabled.
কেন না পড়ে বল না পড়ে কেন বল আমি বলেছি দেখেছি সব আর্গুমেন্ট হয়ে গেছে এখন লিস্ট বার করে এটাই তো হচ্ছে টেন্টেড লিস্ট গুলাটা really I've prompted to make this submission that unless the tainted list, the tainted categories have been defined by the High Court, but they must come out honestly with that list. There are appointees who got appointment after expiry of panel. That is also under the tainted groups.
I have passed an order
Yeah, you have passed an order.
yesterday.
ডাইরেকশন থাকা
এটা তো ডিরেকশন আছে প্রকাশ করে
ডিরেকশন থাকা সত্ত্বেও করেনি
Has that order been uploaded? Not yet.
No. Yesterday's order not uploaded.
Not yet. Alright,
Yeah, but
it's uploaded.
Whether the after expiry is tainted or not.
Yes, only the list to be,
Here from the date of publication.
their names should be,
Now, when the division bench judgment was upheld in toto, there was direction that OMR sheets available in the third hard disk, if not already done, such portion not done must be uploaded in the website of SSC forthwith. But that is also necessary. And in fact, the Supreme Court, bestowed responsibility on this court to ensure that this is done.
which portion did you read out?
Now, this is division bench judgment, paragraph 363, 363,
363 division.
Right.
bench.
Roman III.
All right.
কোনো অনুমতি দেয় তো বুঝতেই পারবে না তো আমি সেটাই বলছি
Yes. Item 27.